हेलो एवरीवन, हाउ आर यू डूइंग? कैसे हो आप लोग? आई होप एवरीवन इज़ फाइन, एवरीवन इज़ फिट एंड एवरीवन इज़ डूइंग वेल. I know it's very tough time for everyone, but we all have to pass it through. And for that, मैं अपने सारे फैमिली मेम्बर्स से रिक्वेस्ट करती हूँ कि आप प्लीज़ बार बार सैनिटाइज करो, हैंड वॉश करो, काढ़ा पियो, मास्क लगाओ एंड टेक ऑल द प्रिकॉशनरी मेजर्स एंड प्लीज़ बी सेफ. ओके, तो फिर चलते हैं अपनी वीडियो की तरफ. टुडेज टॉपिक इज अलॉटमेंट ऑफ सिक्योरिटीज. An allotment of shares is an acceptance by the company of the offer to take shares. The offer of the shares is made on application forms supplied by the company. When an application money is accepted, it amounts to an allotment. First, we will see the general principles regarding allotment and then we will go to the section. So I'm gonna show some examples to make it more clear to understand the general principles.
First,
Hi HP, you are an employee of ABC company. I was thinking to buy shares of this company.
Don't worry yaar, give me the money. I'll make the allotment.
allotment should be made by proper authority. The proper authority may be board of directors or committee authorized by the board. Second,
Ma'am, here's your share certificate. You have been allotted 10 shares of the ABC company.
What? Which share?
Ma'am, the ones you have applied it a year back.
Are you kidding me? After 1 year you are allotting me 10 shares. I no longer need the shares, they are nevertheless fallen below my expectations. I want my money back along with interest.
allotment of securities must be made at reasonable time. An applicant may refuse to take securities if allotment is made after a long time. Third,
I want 5,000 shares of ABC company.
Ma'am, I will allot these shares only if you will show me that you have purchased 200 shares of XYZ Limited Company.
allotment should be absolute and unconditional. Fourth,
Ria, if you're willing to sell your shares of ABC Company, I want to buy it.
What shares are you talking about?
I have seen your name in the register of members book of ABC Company.
Really? I am not aware of it.
allotment must be communicated. Fifth, allotment should not be in contravention of any law. Allotment in private company versus public company.
One of the main distinctions between a private limited company and a public limited company is the nature of allotment or issuance of share. For a private limited company, it is prohibited to issue any prospectus to invite the general public to subscribe towards the share capital. Hence, the share can only be taken up privately by the promoters and their relatives or friends. On contrary, in the case of public limited company, a proper procedure has been set up by the Companies Act for issue and allotment of shares. As per Section 23 of the Companies Act 2013, a public or private company may issue securities in any of the following manners. Public company. To public through issue of prospectus. Private placement, right issue, or a bonus issue. In case of private company, it is right issue, bonus issue, or private placement. Since all these topics are themselves a chapter, so I will not discuss this right now. If you want any particular topic to be discussed, then write it in the comment box. So we will see how generally an allotment of securities takes place. For that, we will have to study Section 39 of Companies Act 2013 along with Rule 12 of Companies, Prospectus and Allotment of Securities Rule 2014. After the public offer, any allotment shall be made only if the amount stated in the prospectus as minimum amount has been subscribed and the amount has been paid to and received by the company by check or other instrument. Now you have to tell me in the comment box that what is the minimum amount or minimum subscription for an allotment to take place. Whenever a company having a share capital makes an allotment of its securities, the company shall, within 30 days thereafter, file with the registrar a return of allotment in form PAS 3 Pass 3 along with the fees as specified in the company's registration offices and fees rules 2014. There shall be attached to the form Pass 3 a list of allottees stating their names, address, occupation if any, and number of securities allotted to each of the allottees, and the list shall be certified by the signatory of the form Pass 3 as being complete and correct as per the records of the company. In the case of securities not being bonus shares allotted as fully or partly paid up for consideration other than cash, there shall be attached to the form Pass 3 a copy of contract duly stamped pursuant to which the securities have been allotted together with any contract of sale if relating to a property or an asset or a contract of service or other consideration. Where a contract is not reduced to writing, the company shall furnish, along with Form Pass 3, a complete particulars of the contract stamped with the stamp duty as would have been payable if the contract had been reduced to writing, and those particulars shall be deemed to be an instrument within the meaning of Indian Stamp Act 1899, and the registrar may, as a condition of filing the particulars, require that the stamp duty payable thereon be adjudicated under Section 31 of Indian Stamp Act 1899. A report of registered valuer in respect of valuation of the consideration shall also be attached along with the contract. In the case of the issue of bonus shares, a copy of the resolution passed in the general meeting authorizing the issue of such shares shall be attached to the form Pass 3. The amount payable on application on every security shall not be less than 5% of the nominal amount of security or such other percentage or amount as may be specified by SEBI by making regulations in this behalf, which is at least 25% of the issue price.
Refund of money.
If the stated minimum amount has not been subscribed and the sum payable on application is not received within a period of 30 days from date of the issue of the prospectus, then company has to refund back the money within 15 days of closure of issue. Let's have a quick recap. सबसे पहले कंपनी इशू करेगी प्रोस्पेक्टस एंड इनवाइट करेगी जनरल पब्लिक को कि वो आके सब्सक्राइब करे उनके शेयर्स. तो इन दैट केस दो कंडीशंस हो सकते हैं, या तो मिनिमम सब्सक्रिप्शन पूरा आ जाएगा या मिनिमम सब्सक्रिप्शन पूरा नहीं आएगा. तो हम वेट करेंगे फॉर 30 डेज़. अगर 30 डेज़ के अंदर मिनिमम सब्सक्रिप्शन रिसीव नहीं होता है तो कंपनी हैज़ टू रिफंड द मनी within 15 days, और in case of default अगर कंपनी within 15 days रिफंड नहीं करती है तो उन पे इंटरेस्ट लग जाता है 15% पर एनम। और अगर मिनिमम सब्सक्रिप्शन रिसीव हो जाता है विद इन 30 डेज तो हमें रजिस्ट्रार को फाइल करना होता है रिटर्न ऑफ अलॉटमेंट इन पास 3 विद इन 30 डेज, और उसके साथ हमें अटैच करना होता है सर्टिफाइड लिस्ट ऑफ अलॉटीज, जिसमें हम उनका नेम, एड्रेस, ऑक्यूपेशन वगैरह लिखते हैं। अदर देन दैट, अगर हम सिक्योरिटीज़ लेते हैं अदर देन कैश, तो उसके साथ हमें अटैच करना होता है कॉपी ऑफ कॉन्ट्रैक्ट विच शुड बी ड्यूली स्टैम्प्ड। इन केस अगर हमने वो कॉन्ट्रैक्ट राइटिंग में नहीं लिखा है, अगर रिटन फॉर्म में नहीं लिखा है, देन वी हैव टू अटैच एन पर्टिकुलर विच शुड बी स्टैम्प्ड, जो हम एक्चुअली में स्टैम्प करते अगर हमने रिटन कॉन्ट्रैक्ट बनाया होता तो। और इन केस ऑफ बोनस शेयर्स, हमें एक रेजोल्यूशन जो हमें पास करी होगी मीटिंग में टू इशू बोनस शेयर्स, वो अटैच करने होंगे। एंड अ रिपोर्ट ऑफ रजिस्टर्ड वैल्यूअर उसके साथ अटैच करना होता है एंड वी हैव टू गिव इट टू रजिस्ट्रार। लेट्स सी द केस लॉ।
Question in this case law was whether in case of reissue of shares return of allotment needs to be filled. A shareholder of Calcutta Stock Limited sued the company for not filling return of allotment during reissue of shares.
Sir, my client is one of the shareholders of the Calcutta Stock Exchange Association Limited. The association is a company limited by shares. The issued capital of the company consists of 277 fully paid up ordinary shares of Indian rupee 1,000 each. Out of these shares, 70 shares were forfeited by the association and later reissued by it. Sir, according to Section 75 of Companies Act 1956, it is the duty of the association to file return of allotment in respect of the reissue of these shares.
Sir, the forfeiture of shares is authorized by the Articles of Association of the Calcutta Stock Exchange Association Limited. Article 21 authorized the Committee of the Association to expel or suspend any member in certain events. According to Article 27, any share so forfeited shall be deemed to be the property of the Association, and the Committee shall sell, reallot and otherwise dispose of the same in such manner to the best advantage for the satisfaction of all debts which may then be due and owing either to the Association or any of its members arising out of transactions or dealings in stocks and shares. Thus, sir, it is now well settled that these articles are lawful and that forfeiture of shares on grounds other than non-payment of calls is valid and is not in contravention of the Indian Companies Act.
Sir, the forfeiture operates as an extinguishment of the forfeited shares so that the reissue of shares is really an issue of new shares in the share capital of the company and that as such the company is bound to file a return of allotment. I am unable to accept this contention.
Sir, the forfeited share reverts to the company, but it continues to exist as a unit of the paid up and issued share capital. The statutory form of the annual return under Section 159 of the Indian Companies Act, 1956, set out in Part 2 of Schedule V of the Act shows that the forfeited shares and the amount paid thereon continue to be part of the issued capital. Thus reissuing it doesn't amount to file new return of allotment. The subsequent sale of the forfeited shares does not increase the subscribed capital. The purchaser does not subscribe for the shares. He buys them. The proceeds of sale do not represent share capital. There is neither a reduction of the subscribed capital by the forfeiture nor an increase of it by the subsequent sale. It is admitted on all hands that in spite of forfeiture the amount paid up on the forfeited share remains part of the paid-up capital. The paid-up capital is part of the subscribed capital. I have, therefore, come to the conclusion that neither a sale nor a reallotment and reissue of forfeited shares is an allotment of shares within the meaning of subsection 1 of Section 75. It follows that the respondent association is not under an obligation to file a return of allotment in respect of the reissue of the forfeited shares. Allotment of shares against promissory note shall not be valid. An allotment may be valid even if some defect was there in appointment of directors, but which was subsequently discovered.
It is because of the doctrine of indoor management. It is assumed that company will take care of the internal management and an outsider will not suffer due to it. I've already explained this case law in detail in my previous video. I hope you have seen it. Those who have not seen it, click on the I button. I hope you liked this video, so keep learning and sharing. Bye bye, see you soon.